Hello. If you've watched this entire series, you now understand more about selling an Alberta business than the vast majority of business owners ever will. You understand corporate cleanup, the lifetime capital gains exemption. You understand the value of a normalized EBITDA. You understand the go-to market process and the NDA. You understand the LOI and which parts of it actually bind you. You understand the asset versus share decision that is so critical and that buyer and seller often disagree on. You understand due diligence and the disclosure schedule. You understand the purchase agreement and what it looks like. And you understand how closing day actually comes about. Now that's a lot of knowledge, but knowledge alone doesn't close a deal. What closes a deal, what gets you from a signed LOI to keys in hand, through every obstacle that arises along the way, is the quality of the people advising you. Your lawyers, your CPA, your financial people. And in my experience, there's one distinction that matters more than any other. I'm Chad Graham, and this is the final episode of From Build to Sold, and I want to use it a little differently than the previous ones. It'll be a little less technical in content than episodes 1 through 9, more of just a conversation between you and me about what I believe makes the difference between a deal that closes and a deal that dies. There are two kinds of lawyers in business transactions. The first kind we'll call the expert risk identifier. They're good at their job, at least in that narrow sense. They will find every problem in your contracts, every gap in your corporate records, every ambiguity in the purchase agreement. And they will tell you accurately that there is risk here, there is risk there, there is risk somewhere else. What they will often not do is tell you what to do about it. Risk identifiers identify, they do not architect. And a client working with this kind of lawyer often ends up more anxious, more uncertain, and more inclined to walk away from a deal, when all along the right structuring could have closed successfully and safely. The second kind of lawyer identifies the exact same risk, the exact same gaps, the exact same ambiguities, but the difference is what comes next. They ask, how do we structure around this? What disclosure protects the client? What indemnity, holdback, or specific contractual language addresses this risk without killing the deal? How do we get our client to a closing they can be confident in? Not a closing in spite of risks, but a closing where the risks are understood, allocated, and documented properly. Now, I aim to be that second kind of lawyer, but you want to make sure whoever you're working with is on the same page. I call this getting to yes. And it's the organizing principle of my entire practice. So what does that actually mean? Let me be very precise because I don't want it misunderstood. Getting to yes cannot and does not mean ignoring risks. Throughout this series, I spent a great deal of time on risks. The LCGE qualification test, the disclosure schedule, the indemnification cap, the MAC clause. Identifying and properly addressing risks is not optional. It's the foundation of everything. Getting to yes does not mean capitulating to the other side. A buyer's counsel pushing for unreasonable terms should be met with firm, well-reasoned pushback. Getting to yes does not mean skipping steps, the corporate cleanup, the proper disclosures, the careful drafting of closing deliveries. None of that is bureaucratic overhead to be minimized. It's the protection that holds up when the deal is done and the years have passed. Here's what getting to yes actually means. It means when a problem surfaces, and in every transaction, problems surface. The first question is never, can we close? As though closing itself were in doubt by default. The first question is, how do we solve this and keep moving towards a closing that protects our client? Now, when a key contract has an assignment clause, for example, requiring consent, the question is not, oh, how big is this problem? It is, how do we approach this counterparty, and what does the commercial ask that gets us to yes? When a buyer and seller disagree on asset sale versus share sale, the question is not, do we have to let the buyer win because they're insisting? It is rather, What is the actual tax cost to our client, and how do we price that into the deal so that both sides get a number they can live with? When a non-compete clause is too broadly defined to be enforceable, the question isn't, should we refuse this? It is, what scope and duration is genuinely reasonable, and how do we document it so it actually protects both parties if it's actually tested? Here's why this distinction matters practically, not just philosophically. Most Alberta business lawyers will sell their business exactly once per lifetime. This isn't a transaction you typically do repeatedly, building expertise with each iteration. It is for almost everyone a one and done, and it represents decades of work and frequently the majority of their net worth. Against that single irreplaceable transaction, you're dealing with buyers. Many are sophisticated. Some are acquisition entrepreneurs who do this all the time. They know the playbook. They know where the leverage points are. The legal counsel on your side of the table is the single most significant factor into whether that asymmetry works against you or is neutralized. A lawyer who reflexively says no, who treats everything as a deal killer, doesn't protect you from that asymmetry. They simply ensure that you either don't sell or that you sell exhausted and demoralized after a process that took twice as long as it needed to. A lawyer who finds the path to yes, while still protecting your actual interests, gives you the closing you are walking towards on terms that are genuinely fair. So I want to say something briefly about the kind of firm that delivers this well, because it's not incidental to the philosophy. At a typical large firm, your file is often staffed by a junior associate whom you've never met. They'll work under a partner who reviews the file maybe an hour a week. At a boutique practice like Chad Graham Law and others, you work directly with your lawyer. If it's me or one of our other great team, your file is not handed off. The relationship is not transactional in the worst sense of that word. A boutique firm also has a direct interest in your success and in your deal being done efficiently. Every unnecessary round of comments, every manufactured issue, every week of delay has real cost to you and a real cost to the relationship we're building. Because I want you to come back again if you have another corporate need. And I want you telling your friends who are Alberta business owners about your experience. I want a 5-star review on Google. Based in South Edmonton and Beaumont, I serve the Edmonton to Leduc corridor, where there are real business people doing real businesses for real people. And I'm genuinely invested in the businesses this series was created for. So if you've made it through all 10 episodes in the series, I want you to know something. Selling your business is not just a transaction from my point of view. It's the culmination, I can't speak sometimes, of years and even decades of work, sacrifice, and risk that you took when most people haven't. It deserves legal counsel that takes your investment seriously. Counsel that fights for your interest when it matters and that finds a path forward when problems arise rather than simply cataloging them. That's what I try to do with every file I bring on. Not recklessness, not capitulation, but a genuine, disciplined effort to get good people on both sides to a fair deal, a win-win. If you're an Alberta business owner thinking about an exit, whether it's in the next 6 months or the next 6 years, I would love a chance to talk with you. Visit chadgraham.law, chadgrahamlaw.com, and book a complimentary consultation. There's no cost, no obligation, just a conversation about where you're at and what the path forward looks like. Thank you so much for watching this series. I hope it has given you knowledge and confidence as you approach your own exit with clarity. I'm Chad Graham. Let's find a way to yes.